the property management industry, fair housing offenses are considered especially troubling. In the United States, a dedicated fair housing attorney, Leslie Tucker, provides case explanations and best practices. These are some cases.
Hello, everyone, and welcome to the Fair Housing Insiders Case Files with Leslie Tucker, the principal of Williams, Edelstein, and Tucker. I am your host, Jonathan Sarr, so thank you for being here today. Welcome back to our channel. Grateful to have all of you. Today, we are discussing a very relevant fair housing case. United States versus Suburban Heights, LLC, Crestline Property, LLC, Triline Properties, LLC, and Jingle Properties, LLC. Joining me today is Leslie, our resident fair housing expert. Leslie, could you start by giving us an overview of this case for today?
Sure, Jonathan. This case involves allegations of racial discrimination under the Fair Housing Act due to the defendant's criminal history screening policy. The U.S. filed a lawsuit against, obviously, several property owners and managers of a community in Missouri, accusing them of maintaining a discriminatory policy that disproportionately affected Black applicants.
Wow, that's a serious allegation. So what specific policies did the defendants have in place that led to these accusations?
The central issue revolves around a criminal history policy that the defendants implemented, and it had been maintained for approximately 9 years leading up to this complaint. This particular property had a policy which was published on its website that stated that applicants' criminal history, quote, must reflect no felony convictions, quote. There was no specific look-back period, no indication of what type of felony offenses this may encompass. So this policy was essentially a full ban on applicants with any felony convictions. And it was really applied without considering any additional factors about the applicant or the offense.
Okay, so this would be considered a blanket policy that excluded anyone with certain criminal convictions at any point in their life, correct?
Yeah, exactly. And the Fair Housing Act prohibits discrimination based on race and national origin, among other protected categories. And while criminal background checks aren't prohibited, you can do them. It's okay. But policies that disproportionately impact any of the protected classes, like race and national origin, they can be considered to have a discriminatory impact.
Got it. So how did this policy disproportionately affect Black applicants?
Well, most people are aware that statistical data shows that Black individuals are incarcerated at rates significantly higher than white individuals, both nationally and in the St. Louis area, which is where this particular property was located. For example, Black individuals in St. Louis City and County are over 5 times more likely to be incarcerated than white individuals. So that means that a blanket ban on individuals with felony convictions are going to disproportionately exclude Black applicants from housing opportunities. And notably, it's mentioned in the complaint that this apartment complex, it was kind of the primary housing that was available in this little city that it was located in, which is around St. Louis, but this was a located in a small city, very, very small. And so this housing community made up a kind of large proportion of the entire rental market in this area. Okay. And since the city's Black population was really rapidly dwindling, the impact of that policy was really that much more costly to Black residents.
Okay. So did the defendants enforce this policy, though?
It appears that they did. The policy, was published on their website, like I mentioned, and the Department of Justice conducted phone and email testing at this property, where individuals posing as prospective tenants with felony convictions. One of the testers said that they had a conviction from 10 years ago. One said they had a conviction from 11 years ago. They asked the property staff if their applications would be denied before they, send in an application. Both testers were allegedly informed by staff at the property that having a felony on their record is grounds for denial, and that the tester really shouldn't waste their time or their money applying.
Wow. So what defenses could the defendants offer for maintaining such a policy?
Without knowing every fact in the case, I would say that the defendants, may argue that their policy was intended to protect the safety and the property of other residents. I think that's ultimately why housing providers come up with policies like this. However, the Fair Housing Act requires that any kind of policy like this, it has to be necessary, and that there really are no other less discriminatory alternatives to achieve that goal. Blanket bans without any additional considerations are generally not justifiable and considered to be discriminatory.
Okay, so are there any recommended alternatives that the defendants could have implemented?
Certainly, yeah. The defendants, I suppose, could have adopted a more individualized approach, which is really what HUD is advocating for now, considering applicants' factors such as, the nature and severity of the defense, how much time has passed since the conviction, evidence of rehabilitation, and other mitigating factors like that. Limiting the look-back period for certain types of convictions would also be something that's highly recommended. And all those kind of factors combined would reduce the discriminatory impact while still addressing legitimate safety concerns at the property.
Okay, got it. So what was the outcome of the case?
Well, the case was just filed in federal court in October of 2024. It's a very new case. It's still open. It is one of many cases that I am seeing now, and maybe you are too, regarding criminal history policies. This is a very active fair housing issue, and it's really only attracting more and more attention by the Department of Justice and HUD and the enforcement agencies around the country.
Yeah, we've had a few shows about this particular topic. We see really the position that the government is taking on topics like this. So from a property management perspective, what are the key takeaways from this case?
First is to avoid blanket policies that categorically exclude individuals based on criminal history without considering how long ago the convictions occurred. That's really, really important. Secondly, it's so crucial that you incorporate individualized assessments into your policies now. Having an appeal process, it's just not good enough anymore. Evaluating applicants that have a criminal history on a case-by-case basis, where you consider and take into consideration factors like the nature of the offense, rehabilitation efforts, mitigating circumstances, the circumstances behind the offense, things like that. And make sure to document when you are having those meetings and making those evaluations. And then lastly, this topic has changed a lot over the last 5 years. It's still evolving as we speak. So it's so important for housing providers to be aware of what changes are happening, how those apply to your property both federally and at the state level as well when you are making your screening policies.
All right, very good. Thank you for those lessons. We appreciate your insights into this case. Always valuable, and it's a powerful lesson for all property management professionals to review their policies carefully. So thanks again for being available for today's episode.
Yeah, my pleasure, Jonathan. Thanks.
Yeah. Thank you for everyone. We're grateful to our community. You guys are awesome. So thank you for being here. If you found this discussion or the show in general helpful, please take the time, give us a thumbs up, like this video, subscribe to our channel so that you can stay in the loop on all things fair housing and property management. Remember that fair housing laws apply to all aspects of housing, and it's our responsibility to ensure equal access for everyone. Until next time, stay informed and stay compliant. Take care, everyone.